Recording stopped. Recording in progress.
We're on the record, Judge.
Shout out when we're ready.
We're on the record.
All right. Case number 21CR0138, State of Ohio versus Derek J. Osborne. And you're Derek J. Osborne appearing on this video screen there at the jail. So, right. The defendant's attorney, Dennis Kirk, is appearing from his office. This hearing is being conducted by Zoom. And also from the prosecutor's office, Assistant Prosecutor Kate, on behalf of the state. The defendant is charged. But before we go any further, Mr. Kirk, you and your client are both agreeable to this matter being conducted by Zoom rather than an in-person hearing in the courtroom?
Yes, Your Honor.
That's all right with you, Mr. Osborne?
Yes.
Okay, thank you. All right, defendant is charged with 2 counts of aggravated trafficking in methamphetamine. Okay, I'm going to have to silence you there, Ben. Yeah, I'm getting that feedback. All right. And 2 counts of aggravated possession of methamphetamine, 3rd-degree felonies. This matter was set for final pre-trial today, and Mr. Osborne, I've been presented a plea of guilty form, which indicates that you're going to withdraw your not guilty plea, plead guilty, and I'll hold that up to camera and see if, well, I'm going to have to change my background here because it makes it more difficult to see. So I see what I need to do. I need to go to a no screen video filter. There we go. All right, now, can you see that form there, Mr.
Yes, sir.
Where it has your name and the case number, and it says you're pleading guilty. There's a plea of guilty form there. See that? Okay. On page 3, there are signature lines, and about halfway down the page, there's a sentence that says, I enter this plea voluntarily. And it looks to me to be a signature of Derek Osborne. I'll hold that up with camera. And do you recognize that there?
Yes, sir.
And that is your signature?
Yes, sir.
When did you sign this document, Mr. Osborne?
Monday.
All right. Yes.
Can I interrupt just for a second? I don't see it when I look on the screen where Adam is logged in, that watching on YouTube, there is a screen, like some kind of a menu screen that covers most of this. You can't see anything.
Well, I just eliminated that a minute ago. But I don't care about YouTube. It's not a, if that's a, let Ben know and we'll have to check and see if that's a technical issue in the courthouse.
Okay.
Yeah. All right. Now, you can see this okay, Mr. King?
Yes, Your Honor.
And Mr. Kirk, you can see it as well?
Yes, Your Honor. Yeah, I don't see anything blocking it.
All right. Well, when I first held it up, there was where I changed my background. There was a menu there. That may be what she was seeing, and I deleted that. So she was standing in front of Mr. King, so that may be what happened. All right. Now, Mr. Osborne, when you sign this document, you understand it was agreed to plead guilty, which means there won't be a trial. The next step in your case will be a sentencing.
Yes, sir.
And did Mr. Kirk explain everything to you and go over it with you before you signed it?
Yes, sir.
And do you feel you had enough time to fully consider this matter before making this decision?
Yes, sir.
And is it your decision to go ahead and continue to go forward with the plea of guilty pursuant to the terms of this agreement?
Yes, sir.
And are you entering into the agreement to plead guilty voluntarily?
Yes, sir.
All right, now, the agreement states that you're going to withdraw your not guilty plea, plead guilty to counts 1 and 4 of the indictment. First count being aggravated trafficking of methamphetamine under 2925.03A1, a 3rd-degree felony. 4th count being aggravated possession of methamphetamine under 2925.11 of the Higher Vice Code, a 5th-degree felony. Further states that you understand that the maximum penalty for these offenses are as follows. Count 1, there could be a prison term of up to 36 months. The minimum would be 9 if the prison term is imposed, and there are several increments in between, starting with 9 and then going up to 36. There's a fine available of up to $10,000. There's a mandatory fine of $5,000, possible license suspension of 6 months to 5 years, and there's a presumption there should be a prison term imposed, although it's not mandatory. You understand that? That's just count 1.
Yes, sir.
Now, as to count 4, it states that you understand the maximum penalty for that could be 12 months in prison. The minimum is 6 months in prison if a term is imposed. There's a fine available of up to $2,500. There's also a possible license suspension of 6 months to 5 years. You understand that?
Yes, sir.
Now, under the law, if you are convicted of both of these offenses and sentenced to prison, the terms could be ordered to be served consecutively, meaning one after the other. So that means there could be a total of 48 months in prison, a possible fine of $12,500, 6 months to 5 years suspension. You understand that? Other than these charges, are you facing any felony charges anywhere else?
No, sir.
Okay, now, under the law, if you are convicted of these offenses and sentenced to prison, once you serve your term, it is possible that the adult parole authority may choose to put you on what's called post-release control supervision at the end of your term of incarceration. And that means that you would be under supervision for a period of up to 2 years as decided by the APA. It doesn't have any follow with that. And if they do that, and they find that you have failed to comply with those conditions, that they can return you to prison even though you served the entire term set by court for an additional period up to 9 months for one violation, but there is a cap or limit of half of whatever prison term is imposed for all violations. However, if you commit a new felony while under post-release control supervision in this case, then in addition, whatever sentence the judge in that new case could impose upon you, that judge could also sentence you in this case for committing that new offense during that period of time while under post-release control, in this case, to 1 year or whatever time is left on the post-release control time, whichever is greater. That occurred, that would be ordered to be served consecutively in the sense of the new case being after. Do you understand that?
Yes, sir.
Under the law, these are not mandatory prison terms, so I am empowered by the law to grant what's called community control rather than prison, which means you can be supervised under the terms set by the court by a probation officer for a period of up to 5 years. If during that period of time the probation department felt that you would not comply, they would have to file a written notice at the court. There would be a hearing, you would be recommended by counsel, and if the outcome of that hearing was you failed to comply, then at that time, the court would revoke your community control and send you to prison for 48 months and fine $12,500. You understand that?
Yes, sir.
Alright, now Mr. Osborne, count 1 of these items alleges on about November 6th, 2020, and you did knowingly obtain, you did knowingly sell or offer methamphetamine, a Schedule 2 controlled amount equal to or exceeding bulk amount, less than 5 times bulk amount violation, of Section 2925, 381. So that's the charge of aggravated trafficking methamphetamine, third degree felony. Count 4 alleges on or about November 12, 2020, in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule 2 controlled substance, to wit, methamphetamine, and that would be the aggravated possession of methamphetamine, the fifth degree felony. Now, Mr. Osborne, do you understand what it is you've been charged with in each of those cases? States that you did, or they allege that you did.
Yes, sir.
And have you discussed the nature of the offenses, the evidence of the case, possible legal issues in the case, possible testing, try to raise the trial, and possible outcome of the trial with your attorney?
Yes, sir.
Now, are you satisfied with this advice and how this matter?
Yes, sir.
Are you under the influence of any types of drug or alcohol at this time? Are you taking any prescription drugs? Now, any threats been made to make you plead guilty here today? Now, on page 2, toward the bottom, there are several lines that are printed in bold and underlined. You see those there at the bottom of the page?
Yes, sir.
All right, I'll read those. They say, defendant shall enter plea of guilty to counts 1 and 4. State will dismiss for 8 counts. State defense attorney recommend 18 months in count 1, consecutive 6 months in count 4. Defendant will pay restitution in the amount of $360 as consideration for the plea. Is that your understanding of the agreement?
Yes, sir.
All right, now, Mr. Osborne, count 1. There is a charge of aggravated trafficking methamphetamine. There is a fine of $5,000 Does anyone promise you anything other than that to get you to plead guilty here today?
No, sir.
Under the law, Mr. Osborne, a matter of sentence is reserved to the judge, not to the parties. So, even though the state and you are both in agreement that you should get a total of 24 months, the maximum prison term costs $48 plus a fine of $12,500 and a license suspension 6 months to 5 years. So, if you plead guilty, after follow the recommendation, I could give you any sentence up to 48 months plus the fine and license suspension. But I think that's appropriate. You understand that?
Yes, sir.
All right, now, do you hold any kind of license or certification from any state agency or board or regulation of any occupation or profession? All right, now you have certain constitutional rights, you must understand, or I can accept a plea from you, and I will go those with you this time. Now, first of all, you have a right to have counsel, Mr. Purpose plan to represent you, not just for the purpose of working your case out, but to provide any defense that might be available to you under the law that you wish you could provide. So, if you decide you do not want to do this, that you'd rather defend against the charge, then we'll continue to represent you and defend you to lead the trial if that's what you want. You understand that?
Yes, sir.
Right, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in this county that are summoned for jury duty on their trial day. After they are selected, the evidence being presented, the judge will instruct them on the law, and that jury will have to decide by unanimous verdict, and all 12 of them will have to agree as to whether or not the state proved your guilt by proof beyond a reasonable doubt. Now, if you decided you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive, which means to give up in writing, the right to have a jury trial. And in that case, you would have what's called a court or bench trial. That means that instead of a jury hearing the evidence, it would be the judge would hear the evidence, the judge would apply the law, the judge would decide whether or not the state found, whether or not the state proved your guilt by proof beyond a reasonable doubt. You understand that?
Yes, sir.
Under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else that's present. After the prosecutor's done asking questions, your attorney has a right to ask questions. That's called cross-examination. And the purpose of that is to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
Now, under the Constitution, Mr. Osborne, you have a right to use the power of the court to compel or force witnesses in court to testify to you, same as state. So, if you have any witnesses you're not certain going to come in voluntarily, at your request, the court issues a court order called a subpoena, and that subpoena would force those witnesses to come to court to be able to testify if you wanted them to, even though they didn't want to be here, which is the same way the state's witnesses are required to come to court. You understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination, Mr. Osborne, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one is even allowed to talk about that or comment about it except in one situation. And that is, if there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Now, under the Constitution, Mr. Osborne, you're presumed innocent until proven guilty on these charges by the state of Ohio by proof beyond a reasonable doubt. What that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to prove anything. You don't even have to present evidence at the trial. You can, but you're not required to. But whether you present evidence in your own defense or not, the burden of proof remains upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of each of the charges, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally, you pled not guilty to the charges, Mr. Osborne. That plea denied the allegations in the indictment, denied that you committed any crime, and exercised or invoked all the rights that I've just described. Now, if you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, that you committed that crime. And that plea would waive or give up all the rights that I've described for you here this morning, except your right to have counsel, because you always have a right to have an attorney no matter what your plea is. But with that exception, your plea of guilty would waive or give up your right to have a jury or court trial, waive or give up your right to confront Witnesses against you in open court, cross-examined through your attorney. Waive or give up your right to use the power of the court to compel or force witness to be in court to testify for you, the same as the state. You would waive or give up your privilege against self-incrimination because you're the one saying you're guilty, and that's supposed to find you guilty. You would waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. Subjects you to being sentenced immediately by the court, which is what's likely to happen and is recommended to happen here in the agreement. And finally, it waives you up any right to file an appeal that you think you may have had up until this point in the case. Should I sentence you to the maximum sentence or under other certain limited circumstances, an appeal could be filed. It would have to be filed within 30 days of your sentencing entry being filed. You understand all of that?
Yes, sir.
Mr. Osborne, are you a U.S. citizen?
Yes, sir.
Right now, do you have any questions about the plea, or I'm sorry, about the charges or the possible penalties?
Yes, sir.
You understand?
Yes.
Have any questions about the plea agreement?
Yes, sir.
You understand?
Yes.
Any questions about the constitutional rights I've explained to you here today?
Yes, sir.
You understand those?
Yes.
Have any questions about the plea of guilty, what it means, or what the consequences of that will be if you enter that plea here today?
Yes, sir.
You understand?
Yes.
Now, if you need to talk to your attorney about anything, I can go ahead and put the two of you in a breakout room where you can discuss anything you'd like to with him before we go any further. And no one else will be present or be able to hear or see. Do you need to talk to him about anything before we go any further?
No.
You have any questions about anything that I've explained to you here this morning?
No, sir.
Right? Then is it your decision to withdraw your not guilty plea and plead guilty to counts 1 and 4 pursuant to the terms of the plea agreement that we've just gone over?
Yes, sir.
Next, then as to count 1, which alleges that on or about November 6, 2020 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance in an amount equal to or exceeding bulk amount but less than 5 times bulk amount in violation of Section 2925.03A1 of the Higher Revised Code, charged of aggravated trafficking of methamphetamine, a third-degree felony, carrying possible prison term of between 9 and 36 months, a fine of up to $10,000, possible a mandatory fine of $5,000, and possible license suspension of 6 months, 5 years. How do you plead?
Guilty.
As to count 4, which alleges that on or about November 12, 2020, in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine, in violation of Section 2925.11 of the Higher Revised Code, charge of aggravated possession of methamphetamine, a 5th-degree felony, carrying possible prison term between 6 and 12 months, fine of up to $2,500, and possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right. The court finds that on this date, open court defendant was advised of all his constitutional rights, made a no intelligent voluntary waiver of the same pursuant to Criminal 11. The pleas accepted in order filed. Defendant is found guilty of counts 1 and 4 as alleged in the indictment. Counts 2 and 3 are dismissed. And let's see, I believe you've served a previous prison term, haven't you, Mr. Osborne?
Yes, sir.
All right.
And I completed my parole in 18 months. I was trying to get help.
All right, I just asked you a question. I'll give you time to read here. All right, well, I'm not going to order a pre-sentence investigation. I'm going to go ahead and proceed with sentencing. But I didn't ask you, are you on post-release control?
No, sir.
Oh, okay, all right. Now, court, then we'll go ahead and proceed with sentencing. And Ben, if you would get the jail time credit there ready.
Yes, sir.
All right, Mr. King, anything you'd like to say?
Only what is contained in the plea agreement, Your Honor. There is restitution in this case of $360 to the Highland County Task Force. Thank you.
All right. Ben, you'll have to unmute the computer there in the courtroom. All right, Mr. Kirk, anything you'd like to say?
Thank you, Your Honor. I would ask the court to follow the plea agreement in this matter. Mr. Osborne has taken responsibility and pled guilty today. In regards to the mandatory fine, he has no source of income. Would ask the court to not impose that due to that fact. But would ask the court to follow the plea agreement and realize with the prior prison term that prison would be likely in this case. And then in regards to the restitution, I did go over that with my client. He does understand that's the blind money. He had no dispute over the amount. Thank you.
And now, Mr. Osborne, is there anything you would like to say? Speak now.
Yes, I do not think prison is going to help me. Much rather do some type of treatment, or if my kids are sick and I need to be there for them. But it's up to you, Judge.
Well, you agreed with the state's recommendation for 24 months, Mr. Osborne. In this case, you're selling, and you're selling bulk amounts, which is certainly much different than possession. And it's not your first time that you've been in prison, as you indicated, and you had a second-degree felony for illegal manufacture before. So, all those things being said, if people need you home, then what you need to do is quit committing crimes and be there for them. But can't look at me and ask for mercy when you're the one that's caused your problem, no one else.
Well,
And so you need to stop selling drugs and take care of your family. So it's a judgment over the court that you be are hereby fined, sentenced on count 1 to a term of 18 months in the Correctional Reception Center in Ohio, and on count 4 to a term of 6 months. These sentences are to be served consecutively because the offenses were committed as part of one or more courses of conduct of one single prison term, not adequately reflect the seriousness of the offense, and the sentence imposed are not disproportionate to the seriousness of the offense. Also, the defendant's prior criminal history indicates that it's necessary for him to be incarcerated on a longer basis to protect the public from future crime. What is the jail time credit there, Ben?
79 days.
59 days. All right. The court will grant 59 days jail time credit based on the sheriff's certification. Now, upon completion of this prison term, Mr. Osborne has indicated it is possible that the adult parole authority will place you under post-release control for a period of up to 2 years. It's optional, so they'll make that decision. If they do, you'll be supervised by a parole officer in the terms they set. And if they determine that you have failed to comply, they can return you to prison and make you serve an additional period of up to 9 months for one violation, up to a maximum of half of your prison term for all violations. But if you commit a new felony while under post-release control, then in addition to whatever sentence the judge in that case could impose upon you, the judge could also sentence you in this case to an additional period of 1 year, whatever time left on the post-release control, whichever is greater. If that occurs, that will be served consecutively sentence in the new case. Now, has there been any change in your financial circumstances since I appointed Mr. Kirk to represent you?
No, sir.
All right. Court then will find that the defendant is unable to pay the fine. There's no likelihood you'll be able to pay it in the near future, so the court waives the mandatory fine. It is ordered that the defendant make restitution amount of $360 to the Huntington County Task Force. That is to be paid through the Huntington County Victim Witness Escrow account, and you'll pay any clerk fees associated with that. You're also ordered to pay the court costs, which has been granted an executioner's order. If you fail to do that, then the clerk could collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. That doesn't collect it then upon completion of your prison term, not while you're in prison, but once you get it completed. The court could order you to do community service in this county and give you credit for each hour you work in an hourly rate set by the court each hour you work. Reduce your judgment by that amount until paid. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor. All right, you're remanded to custody, Mr. Osborne. All right, Mr. Malone's the next one. Sean Malone. All right, this is case number 21CR158, State of Ohio versus Thomas Sean Malone. Malone is appearing by Zoom from Ohio County Jail. His attorney is Dennis Kirk. He's appearing from his office by Zoom, and representing the state is Mr. and is in his office. Now, Mr. Kirk, are you and your client both in agreement that this matter can be conducted by Zoom rather than an actual in-court personal appearance by the defendant?
Yes, Your Honor.
And you're okay with that, Mr. Malone?
Yes,
All right. The defendant is charged 2-count indictment, 1 count of excuse me, felonious assault on a peace officer, a first-degree felony, and 1 count of failure to comply with the order of signaling the police officer. Today, and I have been provided, I'm going to have to change my screen here to delete the background because it doesn't allow me to show you the agreement. All right, I'm looking at a form that says State of Ohio versus Thomas Sean Malone, plea of guilty. I'll hold that up to the camera. Let me take that off the screen there. All right, we'll hold that up to the camera. Do you see that there on your screen?
Yes,
Plea of
Your
guilty
Honor.
form.
Yes.
On page 3, there is a sentence that says, I enter this plea voluntarily, right at the bottom of the page, and the signature looks like Thomas Malone. I'll hold that up to the screen. Is that your signature there that I'm showing you?
Yes, Your Honor.
All right. When did you sign this agreement, Mr. Malone?
Monday.
Right, and was your attorney there with you when you signed it?
Yes, Your Honor.
And did he explain everything to you and answer any questions you had?
He did, Your Honor, yes.
Right? And did you have enough time to fully consider this matter before making this decision? And are you entering into the agreement to plead guilty voluntarily?
Yes, Your Honor.
Right, now the agreement states on page 1 that you're going to plead guilty to an amended charge of felonious assault. And that's, I assume, by deleting the allegation of the peace officer, Mr. King?
That's correct, Your Honor.
All right. And so currently, you're charged with a first-degree felony, which would carry a possible prison term set by the judge of between 3 and 11 years. And there's a possible additional 50% that can be tacked onto that by the Department of Corrections if they determine that you should serve additional time. Now, by amending this to felonious assault, second-degree felony, they're deleting the allegation that your victim was a peace officer, and that makes it a second-degree felony, so it reduces the possible prison term from 3 to 11 years set by the judge to 2 to 8 years set by the judge, with possible extra 50% added on to that. So it's a reduction in the possible sentence. And in count 3, I assume it's being dismissed. Now, the form says that you understand then that the maximum prison term could be 8 years. Again, that's set by the judge, plus a possible fine of $15,000. Do you understand that?
Yes, Your Honor.
And you understand again that you could be required to serve up to an additional 50% by the Department of Corrections. So theoretically, the maximum sentence is 8 years set by the judge, and half of that on top of that would be 4 years, so it'd be possible 12-year maximum prison term. And the minimum could be 2 years set by the judge with no additional time ordered by the Department of Corrections. You understand that?
Yes, Your Honor.
Are you facing any felony charges in any other jurisdiction?
Not to my knowledge.
Now, are you currently on probation, community control, post-release control, or parole for a felony from any jurisdiction?
Right.
Now, if you're sentenced to prison for this offense, which I'll tell you is probable because that's usually what I do in these types of offenses, once you complete that prison term, whatever the court ordered plus any extra time that the Department of Corrections might add on to that, it is mandatory that you be put under post-release control supervision. That means you'll be supervised by the adult parole authority, and a parole officer will be the one that's be supervising you. And that will be for a minimum term of at least 18 months, and it could be up to a maximum of 3 years. So once you complete the prison term, you'd be on post-release control supervision, and it'd be somewhere between 18 and 36 months. You understand that? In the event that you are found by the parole authority to have failed to comply with those conditions, they could return you to prison even though you serve the entire term set by the judge for an additional period of up to 9 months for any one violation, but the maximum would be half of whatever prison term was served for all violations. You understand that? Now, if you commit a new felony while under post-release control supervision, then in addition to whatever sentence could be imposed by the judge in that new felony case, that judge could also sentence you for committing that offense while under post-release control to an additional period of 1 year, or whatever time is left on the post-release control time, whichever is greater. If that occurred, that would have to be served consecutively, meaning after the conviction in the new case. Do you understand that? Now, under the law, it's not mandatory that the court sentence you to prison. So it is possible that instead of being sent to prison, you can be sentenced to a community control sentence, which means probation. That means that instead of going to prison, you'd be supervised by a probation officer under the term set by the court for a period of up to 5 years. If during that period of time they felt you were not complying with those conditions, then they could file a written notice of that with the court, serve a copy on you, and you would then be entitled to have a hearing and be represented by an attorney at that hearing. If the outcome of that hearing was you failed to comply, then at that time, the court could revoke your community control and then send you to prison for 8 years and fine you $15,000. Do you understand that? All right, so the charge as amended in count 1 would read that on or about August 11, 2021 in Highland County, Ohio, you did cause or attempt to cause physical harm to Deputy Steve Alexander by means of a deadly weapon of dangerous illness to a Ford Sport. And the remainder of that would be deleted. That would be then in violation of section 2903.11A2, and that would be the charge of felonious assault, and the second would be felony. Now, do you understand what it is you've been charged with, what the state says you did, when or how they alleged that you did it? You understand the possible penalties for that offense?
Yes, sir.
Now, have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at a trial, and possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with this advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
Yes, sir.
Are you taking any prescription drugs there in the jail?
No.
Has anyone threatened you to make you plead guilty here today?
No.
Now, the form has on page 2 a couple of lines printed in bold and underlined. So I'll read those at this time. Finish, I'll enter a plea of guilty to count 1 as amended. State will dismiss count 2. State defense jointly recommend 3 years incarceration. Is that your understanding of the agreement?
Yes.
Has anyone promised you anything other than that to get you to plead guilty here today?
No.
Under the law, Mr. Malone, the matter of sentencing is up to the judge, not the parties. And so even though there's a recommendation that you should receive a sentence of 3 years, possible sentences range from 2 to 8 years. So if you plead guilty, I don't have to follow that recommendation. I could give you a minimum sentence of up to 8 years, which could be then extended up to 12 years by the Department of Corrections. Do you understand that?
Yes, sir.
Now, do you hold any license or certification from any state, board, or agency regulating any profession or occupation?
No.
Now, you have certain constitutional rights, must understand, Mr. Malone, before I can accept this plea from you first. You do have a right to have an attorney. Mr. Kirk was appointed to represent you in this matter by the court, since you didn't have the funds to employ your own counsel. That appointment wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you would like him to provide. So if you decide you do not want to plead guilty here today, that you want to defend this case, Mr. Kirk will continue to represent you. and defend you, including a trial if that's what you want. You understand that?
Yes, sir.
Now, under the Constitution, Mr. Malone, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens who live in this county that are summons for jury duty on your trial day. After they are selected, the evidence will be presented, they'd be instructed on the law by the judge, and then they would decide by a unanimous verdict, meaning all 12 of them would have to agree as to whether or not the state proved your guilt. Now, if you didn't want to have a jury trial, but you did not want to plead guilty, you could waive in writing, and waive in legal sense means to give up your right to have a jury trial. And in that case, you could have a court trial, which means that instead of a jury being the one who heard the evidence, it would be the judge who heard the evidence, the judge who would apply the law, and the judge would decide whether or not the state proved your guilt or proved beyond reasonable doubt. You understand that?
Yes, sir.
Now, under the Constitution, Mr. Malone, you have a right to confront the witnesses against you in open court and cross-examine them through your attorney. What that means is that the witnesses against you have to come into the courtroom and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney has the right to ask questions. That's called cross-examination. And that purpose of that is to try to bring out evidence that would help your side of the case. You understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, just like the state. So if you have witnesses you're uncertain are going to come in voluntarily at your request, the court will issue a court order that's called a subpoena, and that forces those witnesses to come to court to testify if you want them to, even though they don't want to be here. This is the same way the state's witnesses are required to come to court. Do you understand that?
Yes, sir.
Now, under the Constitution, Mr. Malone, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including the trial. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. And in fact, no one's even allowed to talk about it except in one situation, which is if there's a jury trial and you don't testify, and the court does instruct the jury that because that is your right, they cannot consider that for any purpose. Do you understand that?
Yes, sir.
Right now, under the Constitution, you are presumed innocent of these charges until proven guilty by the state of Ohio on every essential element of the offense charge. So what that means is that the burden of proof isn't on you to try to prove you're not guilty. In fact, under the law, you don't have to present any evidence to defend yourself at all. You may, but you're not required to. But whether you present any evidence in your defense or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Now, originally you entered a plea of not guilty. The not guilty plea denied the allegation in the indictment, denied you committed any crime, and exercised or invoked all those rights I've just described. Now, any event that you change your plea from not guilty to guilty, the guilty plea is the opposite of not guilty plea. The guilty plea admits the allegations of the indictment, admits that there are crimes that you committed that crime. That plea waives, gives up all of the rights that I have just described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what you plead. But with that exception, your plea of guilty would waive or give up your right to have a jury or court trial, waive or give up your right to confront witnesses against you and to cross-examine them through your attorney, it would waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. It would waive or give up your privilege against self-incrimination because you're the one saying you're guilty, and that's what's used to find you guilty. It would waive or give up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if you should be sentenced to the maximum sentence, or under other limited circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. You understand all that?
Yes, sir.
And are you a U.S. citizen, Mr. Malone?
Yes, sir.
Now, do you have any questions about the charge and the possible penalty?
Yes, sir.
You understand it? Do you have any questions about the plea agreement?
No.
You understand?
Yes.
Again, you understand the court's not bound by the recommendation as to sentence.
Yes, sir.
Excuse me. Now, do you understand all the constitutional rights that I read to you, explained to you? Do you have any questions about the plea of guilty, what it means, or what will happen if you enter that plea here today? You understand?
Yeah.
Now, if you'd like to speak to Mr. Kirk, since you're out together in the courtroom, I can put you at the end into a breakout room and let you talk with him privately without anyone else being able to see or hear. Do you need to do that before we go any further?
Yeah.
Do you have any questions at all about anything that I've explained to you here this morning? Then is it your decision, Mr. Malone, to withdraw your not guilty plea and enter a plea of guilty to the reduced charge on count 1 of malicious assault, a second-degree felony, as we just discussed? Then as to the charge, which alleges that on or about August 11, 2021 in Hyde County, Ohio, you did cause or attempt to cause physical harm to Deputy Steve Alexander by means of a deadly weapon or dangerous ordinance to win a Ford Explorer, violation of section 2903.11A2, a charge of malicious assault, a second-degree felony carrying possible minimum prison term set by the judge of between 2 and 8 years, with a maximum being available of up to an additional 1/2 of that minimum term as determined by the Department of Corrections, a fine of $15,000. How do you plead? All right, the court finds on this date open court, the defendant was advised of all his constitutional rights and made no attempts to voluntary waiver of the same pursuant to criminal 11. Please accept it in order to file. Defendant is found guilty of the charge of malicious assault as amended in count 1, a second-degree felony. Given the nature of the offense, the agreed recommendation of the prison term, the court will not order a pre-sentence investigation and will proceed sentencing forthwith. All right, anything further from State?
Thank you, Your Honor. Would ask that the court follow the joint recommendation and sentence the defendant to a term of incarceration of 3 years. There is restitution in this case of $807.48. That figure comes from damage that was caused to a bean field that the defendant drove through while he was being pursued by law enforcement. Thank you.
And who's it payable to?
As to Mike Christopher.
$807 and what?
48 cents.
All right. All right, Mr. Kirk.
Thank you, Your Honor. In regards to the restitution, this is probably the first time my client's hearing about it, because I just received documentation here right before the hearing. The documentation provided to me appears to be calculated by, I'm not sure what organization they're with, but somebody was an expert, went out and assessed the damage and came up with a per bushel amount. So that's where the restitution is coming from. So if my client has any questions about that, needs to meet with me in a breakout room, be happy to discuss that with him.
And the damages for what, Mr. King?
The defendant, when he was being pursued, he drove through a bean field and damaged the crops.
Damage of bean fields. All right.
So that figure's based upon yield estimates.
All right.
And so if my client has any questions about that, I'd be happy to go into a breakout room if he needs that information.
You want to talk to your attorney about that, Mr. Malone, or are you willing to accept that figure?
I'm willing to accept that.
All right.
In regards to the rest of the case, we ask the court to follow the plea agreement. My client has been cooperative through the process and did wish to enter this plea, avoid resources of the trial, did own up to his behavior, and so would ask the court to give consideration to that. His prior felonies are from quite a bit ago, so no, he hasn't had any recent felonies, but he understands the nature of this type of case, that the court would impose a prison term, and his understanding of that. So would ask the court to follow the plea agreement. Thank you.
Mr. Malone, anything you'd like to say?
No.
Yeah. Well, it is a serious offense, and was an officer involved that's been deleted to reduce the possible penalty. But given the nature of the charge and the recommendation from both parties, the court will go ahead and follow that recommendation. And it's order of judgment of the court that you be and are hereby sentenced to the Correctional Central Center in Orion, Ohio, for a period of 3 years, and that would be the minimum sentence as ordered by the court. Now, that could be a maximum of up to 4.5 years, because under the law, the Department of Rehabilitation Corrections could impose require you to serve an additional 1.5 years, which is half of 3. They'll make that decision. So it could be up to 4.5 years. There'll be no fine imposed. You also are ordered to pay the court costs, which doesn't grant execution order. If you don't pay those, then the clerk will collect that through various means, including levies, bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of the prison term, the court will order you to pay service, give you credit for each hour you work. Each hour you work will reduce your judgment by that amount until paid in full. Ben, do you have the jail time credit there for the sheriff?
Yes, sir, Judge. 67 days as of November 3rd.
November 3rd?
Yes, sir.
Okay.
It's an old.
So we need to add, okay, so we need to add 28 days on to that.
Correct.
Okay. So it's 67?
Yes.
67 and 28, then would be 95 days. All right. So you're given 95 days credit for that minimum sentence of 3 years. Now, upon completion of your prison term, Mr. Malone, it is mandatory that you be put under post-release control supervision by the Adult Parole Authority for a period of at least 18 months and a maximum of up to 3 years. Now, if they determine that you failed to comply with those conditions while you're being supervised, they could return you to prison even though you served the entire term set by the court and as expanded by the Department of Correction for up to 9 months for any one violation, up to a maximum of half of your prison term for all violations. However, if you commit a new felony while under post-release control, in this case, then in addition to whatever sentence the judge in that new case can impose, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period, 1 year, whatever time might be left on that post-release control, whichever is greater. And if that occurs, that would have to be served consecutively, or meaning after the other term is completed. The court will also order that you make restitution, pay restitution to Michael Christopher for the damages to his bean crop in the amount of $807.48. That is required to be paid through the Hyde County Victim Witness Escrow account, and you'll pay any fees associated with the charge for that service. That restitution order is a subsequent order, meaning that it has to be paid even if you serve the entire prison term. Serving your term doesn't wipe it out. They'll remain with you until you pay it or you die, whichever occurs first. All right. Count 2 is dismissed. Anything further from counsel?
No, Your Honor.
Mr. Kirk?
No, Your Honor.
All right, you're remanded back to custody and be conveyed to the institution, Mr. Moore. Thank you.